petition arises from the conviction of Arohi Mehra, a 26-year-old entrepreneur and CEO of NeuroSync Solutions, who was charged with culpable homicide not amounting to murder after an incident at the Lexlandian National Cricket Stadium. Suffering from severe PMS and anxiety, she reached instinctively to the alleged harassment by Raghav Singh and unintentionally caused his death. During the investigation, police assessed her neural interaction device logs without her consent or any warrant, and a private neuroanalytics firm, Neurolytics Private Limited, secretly assisted the police in interpreting her neural data. The trial court convicted her, disregarding both her constitutional rights and medical evidence. Aggrieved Arohi now files a special leave petition before this honorable court, challenging the violations of her fundamental rights under Article 14, 20 Clause 3 and 21. And seeking the recognition of a PMS-induced cognitive impairment under Section 84 of the Lexlandian Penal Code. If Your Honor is satisfied, the counsel now proceeds to the first issue of the instant case.
Please.
Much obliged, Your Honor. Our issue 1 starts with whether Arohi's special leave petition can hold, given the trial court's conclusion and the revelations about the neurolytics role. Your Honors, it is to be humbly submitted that the special leave petition here is maintainable as the entire trial starts vitiated due to the grave constitutional violations under Article 20 Clause 3, 21 and the procedural unfairness under Article 14. Moreover, we have approached this honorable court directly under Article 136 because the case raises substantial constitutional and public interest question, especially concerning the neural data privacy, self-incrimination and fairness of trial. The impugned judgment has led to a grave miscarriage of justice and involves the first challenge to warrantless neural data extraction under the Digital and Neural Rights Act, suffering citizens across the Lexlandia. Given the national importance and urgency, approaching the High Court would not have been an equally efficient remedy, so we have approached the Supreme Court under Article 136. Your Lordship, Your Honor, moreover, privacy is an intrinsic part to right of life and to the liberty under Article 21. The warrantless access to Arohi's neural interaction device data constitutes an unconstitutional invasion of privacy. Neural data reveals thoughts, emotions, and mental states far more intimate than biometric data. The vague public interest clause under Section 12 of the Digital and Neural Rights Act lacks procedural safeguards and fails the test of legality, necessity, and proportionality that was laid down in the famous case of K.S. Puttaswamy versus Union of India. Therefore, Section 12, as applied here, violates the petitioner's dignity, autonomy, and personal liberty under Article 21. And, Your Honor, the compelled neural data also violates the protection against the self-incrimination guaranteed under Article 20, Clause 3. The NID logs are testimonial in nature, revealing the petitioner's inner mental process. In the case of Bombay versus Kathi Kalu Oghar, the Honorable Court held that Article 20, Clause 3 protects against self-incrimination compulsion. It was held that mechanical evidence like handwriting, thumb impression, or bodily samples does not violate Article 20, Clause 3. However, testimonial evidence which compels a person to communicate their knowledge, belief, or thought is protected under Article 20, Clause 3. If Your Honor is satisfied, I may move to the second issue.
I have a small query. So, counsel, over here, when you've come before us under Article 136, are you asking us, confining yourself only to questions of law, or you are asking us to reappreciate the evidence as well?
Can you repeat, Your Honor?
Are you asking us to are you sticking only towards questions of law when you're coming forth to us under Article 136, or are you also asking us to reappreciate the evidence?
We're asking for the evidence as well.
For evidence, you need to go to the High Court, not Supreme Court in 136.
But Your Honor, this case usually roams around the public interest, and here her rights are violated, her public interest is violated, and it also rolls around a large public.
So how can an reappreciation of evidence be dealt in the contrast to the public importance?
Your Honor, can you...
Evidence is for your own case, no? How is it even, like, this is not a repetition. This is not something, a form of a PIL sort of a thing. It's a challenge of an order of a trial court. So how is like the reappreciation of evidence, like you just mentioned, be a part of public importance?
Your Honor, I'll get back to you.
Okay.
Your Honor, the vague provision of 12 raises a public interest which has been misused to produce the evidence here in this case.
Will you
Okay.
please proceed with the argument, please?
Okay. Much obliged, Your Honor. Second issue is whether the premenstrual syndrome supported by medical evidence qualifies as a defense of unsoundness of mind under Section 84 of the Lex Landian Penal Code. Your Honor, Section 84 extends to temporary medical conditions impairing cognition. It is to be humbly submitted that Section 84 does not restrict unsoundness of mind to permanent insanity. The key is the mental condition at the time of the act, which was laid down in the case of Dayabhai versus State of Gujarat and Surendra Mishra versus State of Jharkhand, wherein in the case of Dayabhai versus State of Gujarat, it was stated and it was held that what matters is the mental condition at the time of the act, not before or after, which would support the temporary insanity like PMS episodes. Moreover, in the case of Surendra Mishra versus State of Jharkhand, it reiterated that cognitive incapacity at the time of the act is decisive, bolsters that PMS-induced loss of control qualifies under Section 84. Moreover, internationally, it has also been recognized in the case of R versus Smith and R versus Reynolds. They also accepted PMS as a mitigating or exculpatory factor. Similarly, in the other case also, it has been recognized, so it will fall under the Section 84 of the Lex Landian Penal Code. If your honors are satisfied, my co-counsel will be dealing with the remaining two issues. Much obliged,
Please.
Honor.
If your honors are satisfied with the pleading submitted in first and second issue, I'll be moving on to the third and fourth issue.
Please.
Much obliged, Your Honor. Starting with the third issue, that is, did the warrantless extraction of ROE's NIT data infringe your constitutional rights to privacy under Article 21 and protection from self-incrimination under Article 20, Clause 3? Your Honor, we submit that the warrantless extraction of ROE's NIT data by the state has violated her rights under Article 21 and 20, Clause 3, and the state's public interest claim is unsubstantiated and cannot override the fundamental rights. I'll be addressing this in three main arguments, Your Honor. Firstly, we would like to state that ROE Mehra's NIT data violated her Article 21, which ensures the right to privacy and cognitive liberty, since they have intruded into her neural activity and mental deliberations. And Section 12 of DNRA was invoked without judicial deliberations and oversight, which lacks necessity and proportionality, which is governed by the case Puttaswamy versus Union of India and PUCL versus Union of India, which confirm that such intrusions into privacy require clear legal authority and safeguards. And Your Lordship, the seizure here has compounded by Neurolytics analysis, which is a private firm. It seems a bit excessive, arbitrary, and unconstitutional, and has rendered the evidence inadmissible, Your Lordship. Secondly, Your Honor, we would also like to submit that the warrantless extraction of ROE's NID data violates her Article 20, Clause 3, as the data is not mere physical identification, but reveals her personal and behavioral information, which has been used to directly implicate her into this case, Your Honor. And by accessing such information without consent, the state has effectively forced ROE to disclose her private knowledge that she is entitled to withhold, and which has amounted to testimonial compulsion as under the case of Selvi versus State of Karnataka, Your Honor. Moreover, unlike the limited and judicially supervised collection permitted in the cases of Ritesh Sinha versus UP, the authorities here, in our case, have acted without legal authority and safeguards. Thus, Arohi was compelled to be a witness against herself, which requires a full protection of Article 20, Clause 3, Your Honors. Lastly, we submit that Arohi's case does not fall within any legitimate public interest or exigent circumstances. This has been substantiated by the case of Manohar Lal Sharma versus Union of India, which made it clear that national security cannot be used as a bugbear to evade judicial scrutiny, and the state must provide concrete evidence to justify its actions, Your Honors. Now, if Your Honors are satisfied with the pleadings in third issue, I'll be moving on to the fourth issue.
Yeah, please proceed.
Much obliged, Your Honor. The fourth issue is, does Neuralytics' hidden involvement in analyzing her NID data violate her right to fair trial under Article 14 and her autonomy over her data under DNRA? Your Honors, firstly, the hidden involvement of Neuralytics, a private limited linked private firm, in analyzing Arohi's NID data without disclosure or consent violates Article 14, which guarantees a fair trial by tainting the evidence with potential bias, Your Honor. Also, Your Honor, it also breaches her data autonomy under DNRA, Section 4, which Section 4 and 5, which require informed consent and prior notice of purpose for any processing of personal data. Also, the Section 8, which undermines, it also breaches the Section 8, which undermines the procedural fairness and her right to privacy. The Section 8 clearly warrants that the state should, state when acting as a data fiduciary, is legally bound to protect her data and process her data lawfully, which is clearly missing here, Your Honor. And they had the duty to ensure the consent and confidentiality when data is shared with a data processor. They had a duty to engage a data processor only under valid contract, which in our case has been clearly violated since Neuralytics' involvement was hidden. And also according to Section 8, Clause 3, which mandates the data fiduciary to ensure accuracy and scientific reliability of data, is clearly missing in our case, Your Honor. And lastly, in Maneka Gandhi versus Union of India, the court held that procedural laws must be reasonable and just. Similarly, in Fulkuri Kotaya versus King Emperor and Siddharth versus NCT Delhi, they also reaffirmed the principle that an accused is entitled to access all material relied upon by the prosecution. The use of such undisclosed evidence created an imbalance in the proceedings, Your Honors, which has contravened the equality and fairness guaranteed in Article 40. And the covert processing of her NID data by Neuralink has violated her data on autonomy under DNRA, as I earlier stated, and Arohi was neither informed nor given a meaningful opportunity to contest this evidence. And this is further reinforced by the case of K.S. Swami versus Union of India, which recognizes informational self-determination as part of fundamental privacy, which has been breached by the Neuralytics' hidden involvement and has bypassed these protections and infringed both her statutory and constitutional safeguards. If your lordships are satisfied with the pleadings, I'll be moving on to the prayer.
Yeah, please proceed.
Wherefore, in the light of issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this Honorable Supreme Court of Lex India that this court may be pleased to set aside the conviction and sentence awarded to Ms. Arohi by the trial court, recognize that Ms. Arohi's act fall within the ambit of general defense of unsoundness of mind under Section 84 of Lex Indian Penal Code, thereby acquitting her of criminal liability, recognize that the state's warrantless extraction of Arohi's NID data violated her rights under Article 21 and 20 Clause 3, recognize Neuralytics' involvement in analyzing her data as a violation of Arohi's Article 14 right to fair trial, and pass any other order it may deem fit in the interest of justice, equity, and good conscience. Much obliged, Your Honors.
Like, are you taking the defense of unsoundness of mind under Section 84?
Yes, Your Lordship.
So what do you want to say on that?
Your Lordship,
Like either of you could answer.
Your Lordship, it is a valid defense under Section 84, and in various cases, even in India and internationally, it has been recognized that legal insanity will fall under the Section 84 of the Lex Landian Penal Code. So we are taking this defense.
What do you want to say? Like, are there any exceptions to this Section 84 or no? Like
No,
basically, in case, how are you even taking this plea of unsoundness of mind in this particular case,
Your
in the
Lordship,
given facts and circumstances?
Arohi's act, while she acted like that, that falls under Section 84, that she was not aware of her actions when she did that, and this PMS is this is mostly experienced by a lot of women, and for some women it can be so worse and so severe that they're not even aware of their actions, which is done at that point of the act.
So, right, but was Aravi aware of the fact that when she actually fled away from that particular point of time after hitting that gentleman with the ball? So, in that particular scenario, will 84 come into picture or no?
Yes, Your Lordship, because this happens that whatever she experienced at that time of the act, she was not aware, so she did
So,
not
running
know
away after killing someone is something that she is not even aware of.
Your Lordship, she was not aware if that act could have killed him, because it was just a ball, and she
Right.
just
So now we are on a
self-defense.
subsequent act. Right, I understand. Now there are part two of it. Part one is that I was not aware. In my self-defense, probably, I picked up the ball, threw it at someone, he died. So this is part one. Now the part two comes. So once that particular gentleman has died on the spot and the blood is pouring over as to what is being mentioned in the given facts, running away from that situation was something just to safeguard myself, or just in a manner that I was not even aware that what should I do, but I actually flew away from the spot without even informing anyone over the ground, or Mr. Whomsoever, Mr. Vikram Patel, who was supposed to be there with her. So how is 84 going to be applicable on that part two of the facts?
Your Lordship, it will act as a defense under Section 84, because as we have said, unsoundness of mind has been there for a defense in a lot of cases, and it will act, while Arohi's act was not a planned crime. And
Give me one case.
reaction.
Give me one case law in which you actually have the exception of 84 being applicable to your case.
Yes, Your Lordship, I'll get back to you.
You give it to me in the rejoinder or the rebuttal. All right. I'll proceed with the respondent side.
Okay,
If ma'am needs something to ask you, she can.
Yeah, when you're getting back during the rejoinder, also please let us know, are you pleading for temporary insanity or permanent insanity?
Okay,
And
Your
whether
Ladyship.
qualified under Section.
Okay, Your Ladyship, much obliged.
So the respondent side, please now.
The counsel seeks permission to initiate the proceedings.
Yeah, please, ma'am.
Much obliged. Greetings to the bench. The counsel acknowledges the gracious presence of the bench. However, for the sake of the brevity of the proceedings, asks for the kind consent of the bench to collectively address it as Your Honor.
Please.
Much obliged. Your Honor, the counsel shall be representing the respondent in the matter of Ms. Arohi Mehra versus State of Lex India. With the due permission of the bench, the counsel would like to state the statement of jurisdiction.
Please.
Much obliged, Your Honor. Your Honor, the respondent appears before this honorable court under the jurisdiction invoked by the petitioner under Article 136 of the Constitution of Lex India. Your Honor, for the sake of the brevity of the proceedings, counsel seeks permission to move directly with the arguments advanced, or would the bench like to hear the statement of facts?
No, please advance with the argument.
Much obliged, Your Honor.
Thank you.
Your Honor, the current case involves 4 issues for determination. First and second issue, I'll be dealing with it, and third and fourth issue shall be dealt by my co-counsel. So, if the bench is pleased, the counsel would like to proceed with the contentions on the first issue.
Please.
Much obliged. Your Honor, the very first issue is whether this petition is maintainable under Article 136 in the light of the trial court's findings. So, Your Honor, it is humbly submitted that the present SLP lacks merits and therefore is not maintainable under Article 136 of the Lex Indian Constitution. The counsel shall be demonstrating the same in a trifold manner. First, that no miscarriage of justice has occurred. Second, that no substantial question of law exists. Third, that the investigative agencies and the judiciary have ensured compliance with the statutory safeguard. If the bench is pleased, the council seeks permission to proceed with the 3 broad submissions on the issue number 1.
Please, ma'am.
Much obliged, Your Honor. Your Honor, it is humbly submitted that no miscarriage of justice has occurred. At the very outset, Your Lordship, Your Honor, the Council would like to make a reference to the judgment of State of Uttar Pradesh versus Krishna Gopal, wherein the Apex Court held that a miscarriage of justice arises only when the findings are perverse, unsupported by the evidence, or are rendered in violation of natural justice. Your Honor, in the present case, the trial court findings are rooted in consistent evidence, including the CCTV footage, the medical records, and the NID logs. Therefore, the trial could correctly assess that the Arohi's Act was deliberate and not accidental. Moreover, Your Lordship, the interpretation of the data by the experts, whether public or private, it is normal, it is routine in the criminal trials. So therefore, mere allegations of the conflict of interest without any proof of fabrication or a malice cannot nullify the conviction. Thus, the plea of grave miscarriage of justice is wholly untenable. Your Honor, it is further humbly submitted that the present petition does not raise any substantial question of law. Your Honor, the Council would like to draw the attention of the bench to the judgment of Sir Chunnilal Mehta versus Spinning Mills, wherein the Apex Court laid down that the test to determine a substantial question of law must be of general public importance or affect rights of the parties, and if so, it remains unsettled. Your Honor, in the present case, none of the criteria is satisfied. Firstly, the case concerns fact-specific adjudication of the petitioner's conduct, her mental state, the evidentiary weight of her NID data, the credibility of her PMS defense, raising questions of public law systematic interpretation, but are confined to individual culpability under settled penal provisions. Your Honor, secondly, the petitioner has enjoyed a fair trial. She was represented by a competent counsel, and a reasoned judgment has also been given. Her rights have been judicially safeguarded. What she challenges is the assessment of the evidence, thus it doesn't constitute the substantial question of law. Further, Your Lordship, the governing legal questions as to the applicability of the Section 84, the scope of Article 20, Clause 3, 21, admissibility of the digital evidences under the DNRA Act, these are all already settled laws. So the petitioner merely disputes the application to her facts. Your Honor, it is finally submitted that the statutory safeguards under Section 12 of the DNRA Act were thoroughly observed. This section permits warrantless access to the neural data in case of public interest and exigent circumstances. Your Honor, in the present case, a sudden death of a national cricketer inside a high-security stadium, it demanded immediate action. Further, accused had fled. There existed real and imminent risk of the data destruction. Given the petitioner's expertise in the tech field, she possessed technical capacity to alter or erase her NID logs remotely, and therefore waiting for the warrant would have led to the irretrievable loss of such a crucial evidence. So therefore, it was mandatory to do so. If the bench is pleased, then the council would like to proceed with the contentions on the second issue.
Please, ma'am.
Yeah, Council.
Ma'am is asking something.
Yeah, sorry. Yeah, Council, just one question. When you're talking about warrantless action that you've taken, right, in retrieving those NID logs, is it not hit by Article 20, Clause 3?
Your Lordship, the testimonial compulsion, the warrantless access, I just want to confirm that Your Honor means that the warrantless access of this data amounts to testimonial compulsion.
Yeah, does it not amount to testimonial compulsion? It's the thoughts, it's the neural logs are equivalent to thoughts, equivalent to brain mapping. Yeah, please go on.
Your Honor, these NID logs are just like a brainwave patterns, and they do not tell anything about that what one's mind is saying. And even in this case, the NID logs has just shown that she was aware and nothing else. What its interpretation shows us that there were some amygdala levels that were risen, her cortisol levels were risen. They just tell that she was just conscious, just aware, and nothing else. This is not testimonial in nature. It is just physiological and not psychological in nature.
All right, please proceed.
And one thing I want to point out, in case if you go by the facts, so there was this particular mention of a judgment of Kiran Patel. So how is that particular case and this case, how are you differentiating this case from Kiran Patel and the subsequent judgment which actually struck down the provisions of law, like the last page of the facts?
Your Lordship, the council would seek a moment of indulgence to refer to the notes to the judgment.
Please.
Much obliged.
Just to maintain the transparency.
Yes, Your Lordship. Yes, Your
Yeah, so
Honor.
just if you just read that particular last paragraph, so how is this particular case different from Kiran Patel and the subsequent judgment which actually struck down that particular government surveillance programs for its lack of transparency in
Your
light of
Lordship,
Article 20 subclause 3?
Your Lordship, the Kiran Patel versus State of Lex India's judgment stated that the AI-generated evidence is admissible, but it is to be but the procedural safeguards are to be adhered.
So then how are you differentiating it from Article 20 subclause 3?
Your Lordship, but the AI-generated evidence and this NID evidence, it doesn't amount to Article 20 Clause 3 says that any evidence which amounts to testimonial compulsion is prohibitory. It cannot be taken under that. But the NID evidences, it doesn't show the mental state of a person. It is not speaking against herself. It is just showing that she was aware at the time of the act. Only her awareness, only her consciousness. It doesn't states that she has done the act or what she was thinking at that time.
How about proceed?
Just one small query. In case it's showing her brain activity, right, that she was aware, does it also point out towards the fact that there was provocation and initially she was not aggravated, but after certain actions on the part of the victim, she got aggravated? Is that also very clear in that brain activity?
Your Honor, her NID data has shown that her hormonal levels, that all the hormonal levels, which just indicate the consciousness of one's body, so of one's mind and nothing else. So it just shows that continuously she was active, she was aware of what she was doing. That's it. Her NID data shows only this.
Okay, all right, please proceed.
Much obliged. Your Honor, the second issue is that whether the premenstrual syndrome supported by the medical records, which shows the emotional dysregulation, can qualify as unsoundness of mind under Section 84 of the Penal Code or not. So, Your Honor, it is humbly submitted that the PMS supported by the medical evidence of the emotional dysregulation does not qualify as a defense of unsoundness of mind, and the same shall be demonstrated in a fourfold manner. First, that Section 84 must be strictly construed and it applies to total incapacity. Second, PMS does not negate mens rea since Aruhi Mehra knew the consequences of her acts. Third, the comparative and the international jurisprudence show PMS as a mitigating factor and not full exoneration. Lastly, the policy considerations and gender justice weigh against accepting PMS as unsoundness of mind. If the bench is pleased, the counsel seeks permission to present 4 broad submissions on the second issue.
Please.
Much obliged. Your Honor, it is humbly submitted that Section 84 is as codified on the McNaughton rules prescribes that accused can claim immunity only if at the time of the act she was Your Honor, the counsel seeks the extension of just 2 minutes.
Please.
Much obliged. And the Section 84 codified on the McNaughton rules prescribe that accused can claim immunity only if at the time of the act she was laboring under such defect of reason from the disease of the mind as not to know the nature and quality of the act, that it is wrong. Your Honor, courts have consistently held that this must be total cognitive incapacity and not emotional impulse. The counsel would like to bring the attention of the bench to the judgment of Dayabai Chhaganbhai Thake versus State of Gujarat. The petitioners have interpreted it very narrowly, but in this judgment, it was held that the onus is on the accused to bring the evidence to rebut a presumption about the mental capacity at the time of the act. In the present case, petitioner is incapable of proving her mental capacity at the time of the act. Further, in state of Rajasthan versus Sheraram, the court established a clear differentiation between legal insanity and medical insanity, and emphasized that mere presence of the medical condition cannot hold a sufficient basis for cognitive incapacity at the time of the act. Your Honor, in the present case, PMS is a recognized medical condition, but the one which causes emotional stress and physical pain. So, therefore, it is not sufficient to prove the mental incapacity. It is further humbly submitted, Your Honor, that in Ratan Lal versus State of MP, the court affirmed that whether the accused was in such a state of mind as to be entitled the benefit of Section 84 can only be established from the circumstances which preceded, attended, and followed the crime. Your Honor, in the present case, behavior of the accused is representative of an active and conscious mind, along with the intent to cause the harm to the deceased. Additionally, check of the pulse by the petitioner before fleeing the scene shows awareness and presence of a conscious mind. Even if she was facing emotional dysregulation due to the premenstrual syndrome, it did not hamper her ability to anticipate the consequences of her act. Further, Your Honor, it is humbly submitted that even the global jurisprudence has treated the issue of PMS with a cautionary stance and generally recognizing it as a ground for mitigation or diminished responsibility. So this is because PMS is not known to cause a complete lack of awareness of the circumstances. And it is finally submitted, Your Honor, that accepting PMS as unsoundness of mind would risk stigmatizing all the women as periodically incapable of rational action, which contradicts the equality principles. So if the bench is pleased, my co-counsel shall proceed with the contention of third.
Please.
Greetings to the bench. The co-counsel seeks permission to move forth with the third issue at hand.
Yes, ma'am, please go ahead.
Much obliged, Your Lordship. The third issue at hand: did the extraction of Arohi's NID data infringe her rights under Article 21 of the Constitution and Article 20, Clause 3? The Council shall be demonstrating this in a trifold manner. Firstly, the warrantless extraction of NID data is a reasonable restriction under Article 21 of the Constitution. In the landmark case of Justice K.S. Puttaswamy versus the Union of India, this very honorable court held a threefold test, and the Council shall be justifying the actions of the state within this threefold test. Firstly, the test of legality. Section 12 of the Digital and Neural Rights Act explicitly authorizes data access without prior warrant in situations of public interest or exigent circumstances. In this present case, the circumstances clearly existed. The accused Ms. Arohi Mehra had fled the scene immediately after committing the offense. The second test, Your Ladyship and Lordship, is of necessity. The deceased body was discovered in a public stadium, a venue that routinely accommodates thousands of spectators. Swift action was therefore imperative to secure public safety and preserve vital evidence. Thirdly, the test of proportionality. The data was extracted in a narrowly tailored manner and also supervised by senior officials. In the case of R.M. Milkani was the state of Maharashtra. This very court held that the right of privacy must in appropriate circumstances yield to the demands of fair investigation. In this particular case, the investigative agencies were faced with a brutal murder at a public space, followed by the fleeing of the accused and outrage from the general public. Not to mention that Ms. Arohi Mehra is also a prominent person in the tech space, thereby has the ability to tamper with this crucial evidence. If your lordships are satisfied by the first submission, the council seeks permission to move forth with the second broad submission.
Please, ma'am.
Much obliged, Your Lordship. Secondly, NID data does not amount to testimonial consumption under Article 20, Clause 3. The data collected was firstly non-testimonial in nature. Secondly, non-communicative in nature. Thirdly, purely physiological in nature. Indian jurisprudence has historically limited the scope of testimonial consumption to compel oral or written statements that reveal information of personal knowledge. In the state of Bombay versus Kathikulu Olag, an 11-judge bench of the Supreme Court held that collection of fingerprints, handwriting samples, or physical evidence cannot amount to testimonial compulsion. Therefore, the data extracted in this particular case constitutes physical evidence and not compel testimony and cannot fall within the ambit of Article 20, Clause 3. The third broad submission and the last broad submission in this case is the admissibility of the NID evidence. The Supreme Court of Lexlandia in Kiran Patel versus the State of Lexlandia, and if it please the bench, they may refer to para 80, page 32 of the memorial of the respondents. The court held that AI-generated evidence and technology-assisted evidence is admissible as long as the chain of custody is intact and the methodology is scientifically validated. The test of admissibility has a twofold division. Firstly, relevance. Relevance is clearly satisfied because Arohi's mental state is directly at issue in determining culpable homicide, and the NID logs provide contemptuous insight into her emotional and cognitive state. Second test, reliability. Reliability is satisfied because NID device is medically approved and is also widely adopted by the Lexlandian population. If the court is satisfied with the submissions for the third issue, the council seeks permission to move forth with the fourth issue.
Please go ahead now.
Much obliged, Your Honor. The fourth issue, does the role of neurolytics in analyzing her NID data violate her right to fair trial under Article 14 and her autonomy under the DNRA Act? This issue is divided along three broad parallels. Firstly, the petitioner's right to fair trial remains intact. It is respectfully submitted that extraction and analysis by neurolytics does not constitute arbitrariness. This process is satisfied by the twofold test given in Buddhan Chaudhary versus State of Bihar. The first test, intelligible differentia. Neurolytics is not a random private actor. It is a specialized, certified forensic agency equipped with exclusive neural testing technology unavailable in ordinary laboratories. The second test, rational nexus. The involvement of neurolytics directly serves the objective of the statute, namely ensuring reliability, ensuring accountability, and ensuring credibility of the digital forensic evidence. Secondly, Your Lordships, there is a complete compliance with the Digital and Neural Rights Act 2020. The doctrine of necessity safeguards departures from strict procedural rules when larger public interest is at stake. In A.K. Kripak versus the Union of India, this very honorable court clarified that procedural rules exist to advance justice, not to obstruct it. In this instant case, the expertise of neurolytics was indispensable as they are the only specialized agency which could decode such data. Even in arguendo, if there is assumed procedural lapses in obtaining the NID evidence, that does not lead to the inadmissibility of the data in a trial. The Supreme Court in state of Maharashtra versus Natvarlal Damodar Das Soni authoritatively held that irregularity in the process of search does not vitiate either the validity of the seizure or the legitimacy of the subsequent trial. The court emphasized that while procedural safeguards are in fact desirable, their breach does not automatically nullify reliable evidence. The rationale is that the object of criminal adjudication is the discovery of truth, and technical defects in the mode of collection cannot override substantive justice through admissible and credible evidence. The last broad submission in the fourth issue, Your Honor, is that NID data constitutes non-testimonial evidence and is also therefore admissible. If it pleases the bench, the counsel now proceeds to the final broad submission. It is scientific, objective, non-communicative in nature, used solely to corroborate the existing facts. The petitioner was never compelled to confess anything or to communicate any fact of her personal knowledge. The NID data merely showed that the petitioner was conscious at the time of her action, and the circumstantial chain of evidence also shows her conscious decisions. In fact, most importantly, checking of the pulse before fleeing the scene shows the clear consciousness of the petitioner at that moment. It is almost impossible to justify that a person can temporarily lose consciousness for a mere span of seconds and then gain the same consciousness again in the span of that short seconds just after seeing blood. That would suggest that every woman for 3 days a month loses her consciousness and loses all her cognitive capacities from time to time, which is not only patriarchal but also lacks rationality. If it pleases the bench, the counsel seeks permission to move forth with the prayer from the side respondent if there is no
Please, ma'am.
question from the judges.
Please.
Much obliged, Your Lordship. In light of facts stated, issues raised, arguments advanced, and authorities cited, it is humbly requested that this honorable court may be pleased to adjudge, hold, and declare that the special leave petition cannot hold, that this premenstrual syndrome supported by medical evidence of emotional dysregulation does not qualify as a defense of unsoundness of mind, that the warrantless extraction of Arohi's NID data does not infringe her constitutional rights under Article 21 and protection from self-incrimination under Article 20, Clause 3, that Neurolytics' involvement in analyzing her NID data does not violate her right to free trial under Article 14 and her autonomy over her data under the DNRA Act, and or pass any other order which this court may deem fit in light of justice, equity, and good conscience. For this act of justice and kindness, the respondent shall be duty bound forever pray, all of which is humbly and respectfully submitted. But the respondent thanks the court for its time.
Anything you want to ask, ma'am?
Right, I just wanted to ask one thing. In Selvi versus State of Karnataka, they have specifically dealt in detail with brain mapping. Right, how is that brain mapping differentiable from NID logs?
Yes, Your Ladyship. Selvi versus State of Karnataka prohibited forcible extraction of testimonial responses. However, it explicitly stated that non-communicative physical evidence is admissible if collected along with safeguards. In this case, the evidence is non-communicative in nature. The NID logs do not show mens rea or any kind of intent from the side of petitioner. However, it does show that petitioner at the time of the commission of act was conscious. This is corroborated with the physical evidence along with the CCTV footage. Thereby, NID logs is purely physiological in nature and does not, be a similar kind as specified in Selvi versus State of Karnataka, which led to brain mapping or narco-analysis being held not admissible.
Right, like you said, it doesn't disclose any mens rea. So an offense cannot be an ingredient to commit an offense. Be treated as an offense is mens rea. You're saying it does not disclose mens rea. It just discloses the fact that she was conscious. So that also means that it was not a premeditated act. It could have been under grave provocation.
Your Ladyship, I was only referring to the NID data logs that they do not show mens rea. However, the chain of circumstances and the physical evidence do show a clear mens rea and do show awareness of the act. The two parts of a crime are actus reus and mens rea. Actus reus is established by the throwing of the ball. However, mens rea is also established as the action of throwing the ball, and the subsequent checking of the pulse showed that she was conscious, firstly, of the nature of her act. That is why she checked the pulse, to check if the nature of her act had led to the consequence anticipated. Anyone who is not conscious of what that act would lead to or the nature of that act would not have checked the pulse. Thereafter, she fled the scene to escape responsibility. If there was no mens rea and she had come out of her state of assumed incapacity, she could have called for help. However, fleeing the scene after checking the consequence of her action shows a clear mens rea. There is an existence of mens rea. However, the NID logs as a particular reference only show mere cognition being intact.
Brain
Now, I have
mapping.
two things to ask. Sorry, you proceed.
Okay, so brain mapping also only invokes responses via questions, but only the brain activity is recorded, correct? And for NID, there is not only voluntary brain activity that's getting recorded as well as involuntary brain activity. So I think there should have been some sort of judicial authorization, some warrant should have been taken before accessing these logs.
Yes, Your Ladyship. However, in this case, Section 12 of the DNRA permits warrantless extraction in case of urgent circumstances. So, firstly, in this case, Arohi Mehra does have a lot of access in the text space, does have a lot of influence in the text space. So, any sort of going ahead in the proceedings would allow her time to lead to the extraction of data or the removal of data from that space. Secondly, in the case of brain mapping, Selvi versus the state of Karnataka said that brain mapping could be done with a certain amount of safeguards. Even though this is not equivalent to brain mapping, certain safeguards were followed, and statutory provisions allowed investigative agencies to go through with these proceedings, and the investigative agencies have followed due process of law, and there has been no procedural lapse. Therefore, this evidence stands admissible in the court of law.
In case if we speak about the investigating agencies, you are referring to just the local police out there or also to the private firm?
The investigative agencies are the local police. The private firm has merely been brought in for interpretation of the data. They have no role in the investigative findings.
So are they the expert in that particular field to investigate upon your reports and give you a final conclusive report about it? Because ultimately they are also into the competition with the accused firms out there.
In neurolytics, in this particular case, has satisfied the test given in Buddhan Chaudhary versus the state of Bihar, which is the test of intelligible differentia. Neurolytics is not a random private actor or any private company. It is a specialized and certified forensic agency, and thereby the state took assistance from the experts of neurolytics for the mere interpretation of data, where the state's own experts did not have the same amount of expertise. However, they are not a part of the state organization, and they have merely been used for interpretation, which is normal in criminal proceedings.
And it will take the permission of the trial court in order to approach that particular private firm first for their expert opinion?
The trial court was informed of the role of the neurolytics, which satisfies the test given in Preetham Singh case, where judicial oversight is required. Thereby, the actions of the investigative agencies satisfy the test of judicial oversight, as the trial court was aware of neurolytics' role.
And were the counsels for the accused also aware of the fact that you have taken the assistance of the private firm, because the facts say something else?
Your Lordship, in accordance with the facts, the role of neurolytics was found out a week after Miss Mehra's arrest. Miss Mehra was arrested in July. A week after it would be somewhere in the middle of July. However, the trial began in October. So the counsel for the accused had a full 3 months to assess and access the role of neurolytics. Thereby claiming that they did not have access is a false claim. They had more than 3 months to investigate the role of neurolytics, and thereafter in trial they also had an appropriate authority in court to question. In any case, if they felt that the authority should be questioned further, a criminal appeal could be filed, and this is in the High Court if they felt that the judgment was not what they think is just and fair. However, a SLP in the Supreme Court is not maintainable. That is what the respondent is asking for the SLP to be discharged.
All right, let's hear the rebuttals.
Much obliged, Your Lordship.
Thank you.
Moving on to the rebuttals, petitioner, you have 2 minutes.
Before that, my co-counsel would like to answer the questions placed by the Your Honors, which is about the ROE pleading the crime scene.
Also including a rebuttal, whether are you challenging that particular private firm investigations or not?
Can you repeat, Your Lordship?
I'm saying, just like the respondents had mentioned, that you guys were aware about the fact that the private firm was engaged for this particular investigative agencies or put down the expert opinions. So were you aware or you were not aware? So just put that also in your rebuttal.
Much obliged, Your Lordship. So, Your Lordship, we were not aware of the neurolytics involvement in the analysis of our data till after the arrest of ROV. And we were not given time to prepare during the trial phase. We were not able to review the data, and this goes against the Section 8 of the DPDP Act.
Did you challenge that report in a writ petition or otherwise, in case if you're not aware? How can you challenge the report in the SLP?
Can you repeat, Your Lordship?
I'm saying, did you challenge that particular report in any other competent court of law? If not, then how is this even that report been challenged before us in the SLP?
Your Lordship, we have challenged this along with the other privacy violations, Your Lordship, in the SLP itself.
Okay. Rebuttal, please.
So, Your Lordship, we would like to ask the opposing counsel why the Raghav's NIT data was not checked if the state claims to have complied with procedural safeguards, and how can you ensure that you were unbiased while processing her NIT data, given that there was no evidence to review the data processed by Neurolytics, which is a private firm according to Section 8?
You're asking them a question, they need to answer. Or like this is your argument.
Yes, Your Lordship.
No, first you cannot, in a court of law, you cannot just speak to the other side and ask them for an answer. You need to address to the court. One. Second, you need to put all these particular points in your arguments way back. Now you cannot introduce these arguments at a later stage, because these arguments were not being put over by your side when you were given a chance to argue and present your case as a matter of fact. And otherwise also, like just for a matter of concern, you in a court of law, you're only against the judges. You're only putting your points to the judges out there, whomsoever the respective honor judges are. You just cannot question the integrity or the part of the other side, just for your knowledge also. So, but in case if you have just raised these particular points today, let the respondent answer.
Much obliged, Your Lordship. So, for rebuttal, we would like to state that in the case of Girish Chandra versus State of UP, it held that absconding may bolster suspicion but cannot itself constitute as a proof of guilt. Instead, if the accused abscond and fails to offer a credible explanation, their conduct becomes element in guilt. But Your Lordship, in our case, the Arohi was going through PMS and her action lacked mens rea, Your Lordship. Her instinctive flight was a product of shock and was not an attempt to evade justice, which aligns with the case of M.H. George, Your Lordship.
Okay. Anything else you want to add on?
Yes, Your Lordship. I would like to add this thing. That Arohi's act, which they stated that it had mens rea and everything, and she saw and then she flew, it was not a premeditated crime, but a spontaneous reaction which was born out of extreme fear, pain, and stress. Upon realizing that Raghav was injured, she was overwhelmed by panic, shock, and confusion. These are all classic symptoms of acute emotional dysregulation, particularly aggravated during PMS. And my lordship, I would also say that she did not flee out of guilt. She fled out of fear, shock, and trauma. The law judges intention, not instinct. And in that moment, instinct overpowered the reason. Especially, they said that we narrowly interpreted the Dayabagi case, but it was stated in that case that the conduct arising from a state of mental disturbance or shock cannot be construed as evidence of guilt. Arohi's flight was not a calculated evasion, but an instinctive response to overwhelming emotional distress. Much obliged, Your Lordship.
All right. The respondent, I would like to answer, I would like you to answer the 2 points being raised by speaker number 2 first, and then the other part of your argument.
Yes, Your Lordship. The counsel of the respondent will do it that way. The first contention raised is why was Raghav's NID data not extracted? Raghav's NID data does not fulfill the test given in KS Puttaswamy judgment as well as the modern dental health college judgment. The state is not arbitrary in its extraction of data. Extraction of data is only within reasonable restriction, and accessing Raghav's data would be an overreach by the state. The second contention was the biasness of the data extracted. The investigative agencies has proper oversight in the extraction of data. Mere interpretation by experts does not lead to the biasness being questioned. Thirdly, absconding is not mere proof. However, a complete chain of evidence is established in this particular case. Arohi wanted to flee. After hitting the ball on Raghav's face, she had the consciousness to see blood, check the pulse, see that the pulse was not there, and thereafter flee. Fourthly, spontaneity. Arohi's action does not show spontaneity. If it was not calculated in mere spontaneity, the counsel for the respondent argues there was no need to check the pulse of the deceased. And if it was a fear reaction, there could have been a noise, there could have been a call for help. However, it was not fear. It was a calculated strategy to leave that place before the guilt is discovered. The body of the deceased is also discovered the next day. If it was fear, the petitioner could have reached out for help, which might have saved the life of the deceased. Now, the respondent shall be putting their own contentions forward. Firstly, the special leave petition filed by the petitioner does not satisfy the grounds for maintainability under a special leave petition. There is no grave miscarriage of justice. In addition to that, there is no substantial question of law, and the matters raised pertain to the proceedings of a mere criminal trial. Secondly, the grounds of approaching the court by the petitioner remain vague and ambiguous. Ms. Mehra was convicted in a proper criminal trial in accordance with the principles of natural justice. If a criminal appeal is accepted as an SLP, it would dismantle the very foundation of this provision. Thirdly, the petitioner's plea to validate PMS as a valid defense lacks rationality and represents patriarchal notion. This argument would suggest that women periodically and episodically lose their cognition every month, and the burden of any action committed during menstruating should be discharged. The petitioner has also equated medical and legal insanity, which is not true by this court's own judgment, for which the bench may refer to State of Rajasthan versus Shiraram, which is given in para 25 of the memorial of the respondent. Fourthly, Miss Mehra had clear consciousness when she checked the pulse of the deceased and then proceeded to flee the crime scene. Fifthly, the petitioners have mentioned Dayabhai Changni Thakur versus the state of Gujarat in a narrow interpretation. The court has decisively held that the onus to prove incapacity is on the petitioner. It is on the accused to satisfy the standard of a prudent man as held by the court, and the petitioner has failed to do so, hence failing to use the precedent that they have mentioned. Sixthly, the actions of the state were well within the scope of the DNRA Act, which specifies that if urgent circumstances exist, this could not happen. The respondent seeks extension of mere 15 seconds.
Please.
Seventhly, in arguendo, if it was assumed that a minor procedural lapse existed, the state of Maharashtra versus Natwarlal Damodar Das Soni held that the illegality or irregularity of a process does not lead to the evidence not being admissible. Eighthly, the petitioner has mentioned multiple times that NID data reveals thoughts. This is again an attempt to mislead this court. The NID data is merely physiological in nature and does not reveal any thought. It only reveals emotional levels and physiological parameters. That would conclude the rebuttals from the side of respondent. Much obliged, Your Lordship and Your Ladyship.
It's fine.
So respondents have won from our side. You fully convinced us that the conviction was sustainable and we are upholding the same.
Much obliged, Your Lordships.
That is all the best for your future. Don't be disheartened by the results of such moves, but keep on participating. It's going to give you an edge over other legal aspirants coming down the line. Good luck.
Thank you, Your Lordship.
Thank you.
Thank you, Your Lordship.
Your Honor, any feedback for us?
See, for this particular mood or otherwise in the profession?
Sir, both is.
For this mood, I would like to request you for the final round that at least, be clear about the facts, one, be clear about the law and what you need to argue. Because it's very simplicity and very clearly mentioned in the mood preposition that what are the things going against the petitioner side and what are the things going against the respondent side. Typing, researching is then making it as a one particular PDF, reading it throughout is very easy job to do. But ultimately, you need to understand what you're actually arguing. Till the time you don't understand what the law is and why this law particularly has been made by the government or by the statute, whatever, you will not be able to address arguments for a longer run. And this is something I would also like to point out to all of you, because since I don't know how many of you want to actually get into litigation, but in litigation, it's not always about your competence. It's about the other person incompetence, which gets you a favorable order or something like that. Probably you say something that judge might have skipped it, or judge asked you something on that particular day, you answered that particular query with that particular confidence out there. So be your own critic. Like, don't go by what other people say about you. Don't go by what other people actually wants to talk to you about it, and perform well. Like, love this profession, and it will give back to you a lot of things. So don't lose hope. Every day will not be your day, but eventually it's not about single day, it's about the whole life forward. But keep that patience and keep working hard. That is all from my side.
Your Lordship, if it doesn't take too much of your time, any
Yeah.
particular feedback for me? Anything you thought what was
Like,
missing?
don't make repetitive arguments. I'm
Yes,
like,
sir.
yeah, so don't do that. And like you read the whole prayer, so don't do that. It's fine, like pass any orders and so forth. It's fine. So that's a standard for every law, even we do. But we don't read prayers, be very specific as to what you want, because generally when you argue in the court of law, the court is not going to give you much time. You need to put down your best arguments first and then proceed with the remaining arguments. And whenever you go to the court of law, just try to make at least 7 to 8 pointers. Because in case if one pointer gets hit down, the second pointer gets hit down, third pointer gets a hit, and you are back to the case. So you have to, but for that, you have to have a lot of clarity out there and
Yes.
maintain the court ethics and court decorums. That is quite important. And I don't want to point out, but we cannot say to the court that I'll get back to you. So whenever the court asks you something, you need to respond. See, I understand. Whenever you're reading a file a day before, you need to anticipate what the other side can argue, what the judge can actually ask you. So you should be ready. So that is all.
Yeah, also speaker two for respondent. I appreciate the fact that you were well prepared. You had already anticipated the kind of questions we would put forth, and you were prepared with both landmark judgments as well as factual points. So good preparation from your side.
Thank you so much.
All right, all the best.
Request a feedback too, if it's possible.
Understand the law. So that is all for now. And whenever you want to approach us for any sort of an help, we both of us are accessible. So whenever you have any of the doubts coming down your line, either you can take the number from Astha ma'am or somewhere down the line. So we are going to help you, because it's something that we know this profession has given us too much, it's always the right time to give it back to the profession also. So, and it's good to see people, and one thing you should all be proud of is that you are better than the other colleagues of yours who are like your students or your batchmates, whomsoever, because they're enjoying your Sunday. You are actually pulling down a competition which is anyway not been participated by many. So you should be proud of it. But keep on doing it. Don't lose it out. And don't worry about the results. It's a part of the profession out there. So don't be disheartened. And it's like I'm sure Asta ma'am is going to organize another Moot in the coming time. So do participate in it. Because you learn from it. This is your learning curve, and this is going to actually help you in the longer run. Okay.
Thank you so much,
Thank you.
respected
All the
judges,
best.
for your time and providing such insightful feedbacks to the participants. We truly appreciate your effort and guidance throughout the session. Thank you so
Thank you.
much.
All the best for the finals. Thank you.
Thank you. Thank you, sir.
Thank you.
Thank you, ma'am.
Thank you, sir.